Today's discussion will be on the basic features of Indian Constitution. Before we start let us recapitulate certain things. Constituent Assembly first met on December 9, 1946. Its last session was held on 24 January 1915. In between these 2 years, 11 months and 17 days, 11 sessions were held, lots of discussions and debates were taken place, and ultimately India got its own constitution. In the meantime, Jawaharlal Nehru placed his proposal for objective resolution on December 13, 1946. Later on, these proposals guided the principles and philosophy of the Indian Constitution. The Constitution of India started its journey with a preamble, 395 articles, 9 schedules, and some appendices. In its current form, it consists of a preamble, 22 parts containing 444 articles and 2 appendices and 98 amendments to date. For clarification on the basic features of Indian Constitution, we need to go through the component parts of the Indian Constitution, because Indian Constitution is having a very unique feature. India is a multinational state. Through its constitution, framers of the constitution always tried to assimilate these varieties. So, these component parts of India read as follows. It starts with a preamble. Part 1, Union and its territory, which give a glimpse of its federal entity. Part 2, citizenship. Part 3, fundamental rights, which goes very much with the democratic spirit of India. Part 4, directive principles of state policy, which we have taken from Irish Constitution. Part 4A, fundamental duties, which we have inserted in our Constitution through 42nd Amendment Act 1976. Part 5, Union, and Part 6, States. These Part 5 and Part 6, these are unique creations of the framers of our Constitution, which tried to accommodate the features of parliamentary form of government along with the federal principles. Part 7 states in the Part B state, which is now repealed. Part 8, the union territories. Part 9, the panchayats. Part 9A, the municipalities. This Part 9 and Part 9A, these indicate towards having a very sound, profound, solid democratic decentralization. Part 9B, cooperative societies. Part 10, the scheduled and tribal areas. Part 11, relation between union and the states. It's an identification of our federal features. Part 12, finance, property, contracts and suits. We have taken this from Australian Constitution. Part 13, trade and commerce within the territory of India. It is also a contribution of Australian Constitution. Part 14, services under the Union and the states. Part 14A, tribunals. Part 15, elections. It is a democratic flavor. It is having a democratic flavor. Part 16, special provisions relating to certain classes. Part 17, which is very much unique feature of India, languages. Part 18, emergency provisions. Actually, when India started its journey, the framers of Indian Constitution were a bit confused whether to have a unitary model of government or a federal one. At that time, there were conflicting interests, namely Indian National Congress, Muslim League, princely states and several others. So, federalism was found most suitable. But at the same time, Indian framers of Indian Constitution or the builders of its nation, statesmen, they wanted to accommodate a centralizing tendency with the federal spirit. Part 18, that is emergency provisions, is a very good exhibit of this intention. Part 19 Miscellaneous, Part 20 Amendment of the Constitution, Part 21 Temporary, Transitional and Special Provisions, Part 22 Short Title, Date of Commencement, Authoritative Text in Hindi and Repeals. These are the component parts of the Indian Constitution. If we go through the component parts of the Constitution, few things will be apparent. First, there is a good attempt to blend the principles of parliamentary form of government and the principles of federalism. Two, there is an attempt to accommodate the socio-economic and cultural diversities and variations within the Constitution. And of course, there is an attempt to improve the conditions of the downtrodden. Now, let's have a look at the unique assimilations Indian Constitution accommodated within its structure. Indian Constitution actually got its features from the constitutions or world constitutional experiences. From Britain, it adopted parliamentary form of government, rule of law, role of the speaker, etc. From USA, it got federal principles, it got due process of law, independence of the judiciary, etc. We have got our directive principles from Irish Constitution. Canadian Constitution contributed us by providing an instance of quasi-federal form of government. We are indebted to Australian Constitution for freedom of trade, commerce between different states of the country and power of national legislature to make laws for implementing treaties. India is a democratic country and we must bow down to the French Constitution for leading us, for guiding us with its ideals of liberty, equality, fraternity. Japanese Constitution has contributed to the framing of our Constitution with its unique form of fundamental duties, and it teaches us the rights are allied with duties. They are two sides of the same coin. Emergency provisions, we have got it from Weimar Constitution, and we have got the concept of concurrent list from the Malaysian Constitution. Now, let's turn our eyes to the features of Indian Constitution. As we know that Indian Constitution is the largest written constitution in the world. It has a unique blend of rigidity and flexibility. Indian Constitution is a democratic republic. Indian Constitution nurtures a parliamentary form of government as well as a federal form of government. Indians are having single citizenship, not like USA. People of USA enjoy dual citizenship, one the national one and the citizenship of their own state. Adult suffrage is a very prominent feature of Indian democracy. We have fundamental rights. We have encoded directive principles of state policy, though they are not justiciable, yet they are fundamental in the governance of the country. We have encoded fundamental duties. We have independent judiciary, which is not very familiar with parliamentary form of government, but because we have already accepted federal form of government also, therefore, we have accommodated this independent status of judiciary within our framework, and India is always crazy for creating a secular state, so secularism is a very good feature of Indian Constitution. Let's go for analyzing these features in detail. India is having the largest constitution. Originally, when American Constitution started its journey, it had 7 articles. Australian Constitution had 128 articles. Canadian Constitution had 147 articles. Indian Constitution started its journey with 395 articles divided into 22 parts, 9 schedules. Now we have already stated that we are in our constitution there are 444 articles. Now the question is, why it is largest constitution of the world? The simple answer is, the framers of Indian constitution tried to assimilate so many of the good attributes from the world constitutional experiences. As we have already discussed, from Britain, from USA, from Australia, from Japan, we have accommodated relevant features and we have given them place in the Indian constitution. It has made Indian constitution a very large one. Secondly, unlike American constitution, Indian constitution, while adopting its a federal form of government, has accommodated the form of state government and local bodies in its in the framework of the constitution itself. In America, only there has been enumerations on the union government, but in India, governments of the state and the local bodies have also taken due place. There is a harmonious blend of rigidity and flexibility. According to Article 368, Indian Constitution can be amended in 3 ways. One is flexible, one is a good mixture of flexibility and rigidity, and the third one is very rigid. The parts which are very flexible can be amended by ordinary lawmaking process as it is done in the parliament. The second part, which is partly flexible and partly rigid, needs to be amendment of those parts needs to be proposed in the houses of the parliament, in any one of the houses of the parliament. And such proposal must be approved by at least half of the total membership of that house. Half of the total membership of that house, that is, majority of the total membership of that house, and not less than 2/3 majority present and voting. That is, present on that day and voting on that day. So, or at least 2/3 majority present and voting must give their approval for amending certain parts of the constitution. And the third one, it is absolutely rigid because it not only needs to go through the second path, but also it needs to be ratified by at least half of the states. That is, after getting its approval from the parliament, it needs to be ratified by at least half of the states. One thing we must remind, that proposal for amending any of the parts of the constitution must be initiated in any of the houses of the parliament, not in the state legislative assembly. India has declared itself as democratic republic. What is democracy? Democracy is a form of government where people are free to cast their vote and to stand election to form government. It is not possible to have a direct democracy, so in today's world we are having indirect democracy. That is, representatives of the people, they are entitled to rule the nation. In this way, India is of course having its own democratic feature. It is republic because both the head of the state, that is the president, and the head of the government, that is the Union Council of Ministers and the Prime Minister, as well as the government in the state, they are elected by the people. President is indirectly elected, and Prime Minister and his Council of Ministers, or the Chief Minister and State Council of Ministers, they are directly elected by the people. Whenever in any form of government there is no scope for being or for having a hereditary ruler, it is called republic. So, unlike Britain, India is having its democratic republican feature. Sometimes critics say that India is a member of Commonwealth and head of the Commonwealth is the British king, who is a hereditary ruler. So how can India designate herself as a republic? But we have to note this point. First of all, we have accepted the membership of Commonwealth voluntarily. It is not mandatory for us to be the member of Commonwealth. And secondly, king or queen is only the symbolic head of the Commonwealth. India has accepted parliamentary form of government. What is parliamentary form of government? In this form of government, executive is responsible to the legislature and remains in power only as long as it enjoys the confidence of the house. Which house? The lower house, that is Lok Sabha, that is where people directly send their representatives. The President of India is the constitutional head. As we know, the system of parliamentary form suggests. The Union Council of Ministers, as with the Prime Minister as its head, is drawn from the legislature. It is collectively responsible to the House of the People, that is Lok Sabha. The Union Council of Ministers act as real executive. In the states also, government is structured in this way. So, all the norms of parliamentary form of government are being followed in India, so we are having a parliamentary form of government. But it is very much unique. It is unprecedented that India at the same time has accommodated the features of federalism. If I go through the constitution, nowhere it has been stated that India is a federalism. Nowhere it has been uttered that India is a federal country. How it starts? Article 1 of Indian Constitution starts like this. India, that is Bharat, is a union of states. The word federation is not used, but still the government is federal. Let's go through the features of federalism. There are two sets of government. In a federal nation, there are two sets of government and powers are being distributed among these two sets. In India, there are obviously two sets of government, and even in India, in the constitution itself, it has been recognized, as we have already discussed. Powers are being distributed among the center and the states. In the 7th schedule of the constitution, there are 3 lists: union list, state list, and concurrent list. Concurrent list, I have already told that we have accepted this from Malaysian constitution, and in the union list, central government is empowered to act. In the items of the state list, state will act, and in the items of the concurrent list, both the center and the states are empowered to act. However, the laws or decisions of the state shall be declared void if it is repugnant to any of the provisions of the union law or union decision. India is having its independent judiciary, but one thing we must be clear about, that it is not exactly the federal setup as it is in USA. In USA, there are 2 sets of judiciary, one in the center and the other in the states. Within the jurisdiction of the state, Supreme Court is supreme. That is, it has got very limited appellate jurisdiction. But India is having an integrated judicial system with a wide appellate jurisdiction. Casey Ware has termed Indian federalism as quasi-federal. That is, it is a quite good blending of federal and unitary features. It has always been stated that India is actually a unitary state with some federal features. However, India has accommodated federalism in accordance, in compliance with the situation of India itself. Now, Indian Constitution, of course, permits integrated judiciary, single citizenship, as well as single constitution and single all India services. These are all non-federal features or unitary features. However, still in this multinational state with linguistic variations, cultural variations, religious variations, Indian federalism is running well. Second, next feature is fundamental rights, wide articulation of fundamental rights. We have accepted fundamental rights from the world constitutional history, as well as we have been influenced from UN Declaration of Human Rights. Previously, we had 7 categories of rights. Now we have 6 categories of rights. These are right to equality, Article 14 to 18, right to freedom, Article 19 to 22, right against exploitation, Article 23-24, right to freedom of religion, Article 25 to 28, cultural and educational rights 29-30, and right to constitutional remedies, Article 32. Article 31 was there before 1978. Article 31 assured us with right to property, which is not there in the Indian Constitution as a fundamental right. It has become a legal right by insertion of Article 300A. It is now merely a legal right. So, these fundamental rights, they are justiciable. As I have already stated that Article 32 gives us right to constitutional remedies. It means that we can move to the Supreme Court for enforcement of right, that is, against infringement of any of the fundamental rights. We can move to the High Courts by Article 226 for enforcement of fundamental rights as well as legal rights. But so far as Article 32 is concerned, we can move to the Supreme Court only for enforcement of the fundamental rights. And what the courts can do? They can issue writs. There are 5 types of writs: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. In specific cases, courts issue these writs for enforcement of these rights. So far as directive principles are concerned, they are non-justiciable. But still they are fundamental in governance of the country, as has always been stated by the Supreme Court. Actually, when India started its journey, it could not secure right to work for all, equal pay for equal work for all. So these were being inserted in the Part 4 of the Constitution, that is in the directive principles, where there is a provision for equal pay for equal work, free and compulsory education for all, old age assistance in unemployment, and Indian government has made several laws to enforce these directive principles. Part 4A, as I have already stated, guarantees certain fundamental duties. There are certain other features of Indian Constitution, like in several provisions of the Constitution, there are avenues to improve the conditions of the downtrodden, the scheduled caste, scheduled tribes, and other backward sections of the population. So, India is having a very rich constitution with very unique and enriched provisions, and now it is up to ourselves how to move ahead with this rich documentation, though a legal one, but absolutely we can go ahead for a socio-economic revolution with this pious Indian Constitution.